This is Attorney Christopher Ripley. I am an attorney with CCSK Law. All right, let's talk for a minute about digital assets. Now, this really came to the forefront within, say, the last 10 years. Now, when we talk about digital assets, we need to start with some definitions. What's a digital asset? At least in Indiana, under the Indiana statutes, digital assets are those things of a completely electronic nature. And so, say, a bank account that you can access online is not a digital asset just because there's an online, portal for the account. It's still going to be, a liquid asset that is handled differently than a strictly digital asset. A digital asset is going to be things like your Facebook account, or an email account, or photographs that are stored, say, up in the cloud, managed through, say, Amazon or Apple or things of that nature. Now, as to why we would want to manage these assets, that should be fairly straightforward. This is we need to begin incorporating those assets into comprehensive estate planning and even designations of, say, agency under a power of attorney. Because if something were to happen to us, if we were to pass away or become disabled, somebody may need access to those accounts, or may simply want to be able to wind up those accounts or pull down sensitive emails, or store, say, photographs, for example. And if the principal, the owner of the account, is not able to act, somebody else needs to be designated with that authority in order to access the accounts. Conventionally, simply, using a loved one's password is not a legally appropriate way to proceed. Now, in 2017, or thereabouts, the state of Indiana addressed this issue by updating the statutes relating to powers of attorney, wills, trusts, and guardianships. This was done through cooperation with a wide variety of stakeholders, Google, Apple, so on, kind of big tech providers, as well as Hoosiers and the legislature, went back and forth as to the appropriate wording and structure of these statutes. And at the end of the day, the legislature came through with a very comprehensive statute that allows Hoosiers to tailor the estate plan to take these accounts into account as part of their estate plan. Now, the first overarching thing to deal with is that the top priority for digital assets is going to be given to the program itself, the account management, essentially, widget inside the account itself. Many of these account providers, say, for example, Facebook, have applications within the account that allow an individual to designate access in the event of their passing. If an account provider has that program in place and it is used by the account owner, the designations in that account designation are going to control. And that's, step one of the statute. If not, if those, if either that widget doesn't exist or it hasn't been utilized by the account holder, then there are processes through which, say, a personal representative in an estate or an attorney, in fact, under a power of attorney, can access those digital assets. This may require working with a court to get a court order to, say, get Facebook to open up the file, or there may be less involved processes depending upon the individual situation. But at the bottom line is that there is now an avenue to make sure that those elements are preserved, so that if somebody does pass away or become disabled, those accounts can be monitored, and the essential pieces can be preserved for posterity, and particularly photographs or video can be preserved and maybe distributed to family members, as this may become the sole way that people, say, store those family photographs that may be valuable generations down the line. The bottom line is that these provisions are incorporated into the accounts themselves and should, as part of a comprehensive estate plan, be incorporated into powers of attorney, wills, trusts, and potentially guardianship proceedings as needed to fulfill the goals of that planning. If you'd like more information or have any questions, please don't hesitate to contact us at CCSK Law, 57 Michigan Avenue, Suite 101, here in Valparaiso, Indiana, 46383, or give us a call at 230-3600. On the website at ccskallaw.com.